Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In today's lecture, we are going to discuss section 15 to 21 of Bharatiya Sakshya Adhiniyam.
Today, we're diving into a really fundamental topic from the Bharatiya Sakshya Adhiniyam 2023. We'll be breaking down Section 15, which defines admission. This concept is absolutely crucial for both civil and criminal cases, so let's get right into it.
So here's how we're going to tackle this. First, we'll introduce Section 15. Then, we'll decode what the definition actually means. After that, we'll look at a practical example and a landmark case to see it in action. We'll also clear up the difference between an admission and a confession, which is super important. And finally, we'll focus on why this matters for your exams and do a quick revision.
All right, so let's start with the basics. In the law of evidence, admissions are a pretty big deal. But why is that? Well, think about it. These are statements made by a person who is part of the case. The law basically works on the idea that if a person says something that goes against their own interest, it's very, very likely to be true. And this core idea is what's captured in our new evidence law.
So let's get started. Today we're going to discuss Section 15 of the Bharatiya Sakshya Adhiniyam 2023.
Now let's look at the exact words used in the law. Understanding the language of the bare act is the most important part.
The Act says an admission is a statement, and this statement can be spoken, written down, or even in an electronic form, like an email or a WhatsApp chat. The key part is that this statement has to suggest an inference, basically a logical conclusion about a fact and issue, which is the main point of disagreement in a case, or a relevant fact that's connected to it. So, if we break that down, there are three essential ingredients. First, you need a statement, in any form. Second, that statement must suggest an inference, meaning it has to point towards some conclusion. And third, this conclusion has to be about a fact in issue or a relevant fact in the case. A statement only becomes an admission when all three of these things are present.
Okay, that's the theory. But how does this play out in the real world? Let's use an example and a landmark case to make this concept crystal clear.
Let's imagine a simple scenario. Suppose A files a lawsuit against B to get back 50,000 rupees. Now, during this time, B writes a letter to his friend C, and in that letter he says, "I owe some money to A, and I need to repay it." See? That statement right there in the letter is a classic example of an admission. It suggests his liability, which is the main fact in dispute.
Now, a very important case you should remember is Narayan Bhagwantrao Gosavi. In this judgment, the Supreme Court made a huge point. It said that admissions are substantial evidence. What that means is a court's decision can be based entirely on an admission. It has its own weight. But, and this is a big but, the court also said admissions are not conclusive proof. This means the person who made the statement gets a chance to explain it or even prove that it wasn't true.
All right, let's talk about something that often comes up in the mains exam. The difference between an admission and a confession. This is a favorite question for examiners, so let's make sure we have it down perfectly.
Let's break down the differences. First, think about the type of case. Admissions can be used in both civil and criminal cases. Confessions, on the other hand, are strictly for criminal cases. Second, let's look at the content. An admission just suggests something about a fact. A confession is way more direct. It's a clear statement acknowledging guilt. And finally, who can make it? An admission can be made by any party in the lawsuit, but a confession can only be made by the person accused of the crime.
Okay, let's switch gears and focus specifically on your exams. It's really important to know why this section is a big deal and how it relates to the old law you might have studied.
For those of you familiar with the old laws, this section isn't brand new. It was earlier Section 17 of the Indian Evidence Act of 1872. That act has now been replaced by the Bharatiya Sakshya Adhiniyam 2023. So the core idea is exactly the same, just the section number and the name of the act have changed.
And please make a special note of this. This section is extremely important for both your judiciary prelims and mains exams. For the APO exam, you can definitely expect direct questions on its definition, its ingredients, and of course, the difference between admission and confession.
All right, we've covered a lot. Before we wrap up, let's do a super quick revision of the key points so they stick in your memory. So what did we learn today? Let's recap. First, Section 15 of the Bharatiya Sakshya Adhiniyam 2023 is what defines admission. Second, the main idea is that it's a statement, whether spoken, written, or electronic, that goes against the interests of the person making it. And third, remember this for your exams. It's considered substantive evidence and is a hot topic for both judiciary and APO exams.
For more judiciary-focused legal content like this, make sure you stay connected with us here at Genga Education.
Have you ever stopped to think about a really strange but powerful idea in our legal system? The idea that someone else's words could legally become your own. I mean, imagine being held responsible for something you never actually said. It sounds a bit wild, right? But it's a real rule, and it completely shapes how accountability works, especially today. So let's just dive right into the heart of it with this question. You would think, pretty logically, that in a courtroom, you're only on the hook for what you say. But what happens when the law says, not so fast? Okay, first things first, let's get a key term straight, an admission. In legal terms, this is basically any statement you make that hurts your own case, and courts give these statements a lot of weight. Why? Well, because who in their right mind would say something against their own interest unless it was true? Now, here's where it gets really interesting. We're not talking about your words anymore. What about the words of your business partner, or the trustee managing your family's assets, or heck, even the person who sold you your property? Can their words come back and legally bind you? And this is exactly where the law provides a very specific answer. It's called Section 16 of the New Evidence Act, the Bharatiya Sakshya Adhiniyam. This rule is designed for the real world, where we constantly rely on other people to act and speak for us. You know, there's this old Latin saying that just perfectly captures the whole idea. He who acts through another acts himself. It's so simple, but so profound. The law basically sees the actions and the words of your authorized representative as if they were your own. All right, so if we're talking about people who can legally speak on your behalf, who exactly falls into this category? The law is very, very specific about this. So let's break down who these key players are. First, you have the agent. This is the obvious one, right? Your manager, your lawyer, someone you've authorized. Then there's the representative. Think of a trustee for an estate or a guardian. A really interesting one is the predecessor. Let's say you buy a piece of land. What the previous owner admitted about that land can actually be used against you. And finally, any interested party, someone with a direct financial stake in the matter. Their words count too. But wait, it's not enough to just know who can speak for you. There's another huge piece to this puzzle: when they say it. And on this point, the law is absolutely crystal clear. And this, right here, is the golden rule. Timing is everything. For a statement to be considered a valid admission, it must have been made while that person still officially held that role or had that financial interest. So if your business manager says something a week after you fired them, nope, doesn't count. Their authority is over. So what this does is give the court a really simple but powerful checklist. Step 1, who said it? Are they one of those key players we talked about? Step 2, when did they say it? Were they still officially connected to you? If the answer to both of those is a solid yes, then boom, you've got yourself a valid admission. Okay, so we get the rule, we get how it works, but let's take a step back. Why does this rule even exist in the first place? What's the whole point of making someone accountable for another person's words? Well, it really all boils down to fairness and accountability. This rule stops people from playing games. You can't just hire someone to conduct your business, and then, when something goes wrong, turn around and say, oh, I never said that. It forces you to stand by the words of the people you've empowered. And honestly, it just makes the whole justice system run a lot more smoothly. All of this sounds good in theory, right? But how does it actually work in a real courtroom? Let's look at a few landmark cases from India, where this very rule was the deciding factor. For example, in the Moksh Builders case, the Supreme Court said that even the government is bound by the statements of its authorized officers. In Basant Singh, the court confirmed that a new landowner was bound by what the previous owner had admitted. And the Karam Kapaihi case made a crucial distinction. When a trustee speaks, it's the trust they are binding, not themselves personally. These cases really bring the rule to life. So let's say a statement gets past the test. The court accepts it as a valid admission under Section 16. The really big question then is, so what? How much does it actually matter? Just how powerful is this piece of evidence? And this chart gives you a fantastic visual. An admission is considered substantive evidence, which is huge. It means it's strong enough on its own to be a major factor in a judge's decision. It can even shift the entire burden of proof, forcing the other side to prove the statement was wrong. But, and this is important, it's not the final word. It's not conclusive proof, so you do get a chance to explain it or contradict it if you can. All right, we've covered a lot, but if you take away just one single thing from our discussion today, I want it to be this. This is the absolute core of it all. In the eyes of the law, your legal identity isn't just you. It's an entire network that includes the people you authorize to act and speak for you, and you're bound by what they say. It's a fundamental principle of how legal responsibility works. And that kind of leaves us with a fascinating final thought, especially for the world we live in today. With AI assistants, social media managers, and complex global teams, the line of who's representing who is blurrier than ever. And this old legal rule forces us to ask a very, very modern question. Who, right at this very moment, might be speaking for you?
आज हम डिस्कस करेंगे सेक्शन 17 of the Bharatiya Sakshya Adhiniyam 2023.
So, have you ever thought about this? When can a statement made by a complete stranger actually be used against you in a court of law? It sounds a little strange, doesn't it? But there are very specific situations where a third party's words can become a formal, binding admission in your case. And that is the exact legal puzzle that Section 17 is here to solve. All right, so let's get right into it and start with the basics. To really understand this principle, we first need to look at the foundational text of the law itself and, what it's really trying to do. So, the provision we're focusing on today is Section 17 of the Bharatiya Sakshya Adhiniyam 2023. This section is specifically designed to handle those tricky situations where a statement by someone who isn't even part of the case suddenly becomes super important. Now, let's look at the key line from the BEAR Act. It says, statements made by persons whose position or liability it is necessary to prove as against any party to the suit are admissions. Okay, that might sound a bit complex, so what does it mean in simple language? Well, it just means that if you're in a lawsuit and to win your case you absolutely have to prove the legal responsibility of a third person, then any statement that third person made about that responsibility can be used as an admission. So how does this actually work in practice? To figure that out, we need to decode the key ingredients. Let's break down the essential conditions that absolutely must be met for this section to apply.
इस section के apply होने के लिए, you need to remember these 4 essential conditions. Think of it like a checklist. First, the statement must come from a third person, someone who is not actually a party in the lawsuit. Second, that person's position or liability must be a central issue, not just some minor detail. Third, the statement must be relevant against them, meaning if that third person was sued directly, this statement could be used against them. And fourth, and this is crucial, the statement must have been made while holding the position. All 4 of these have to be satisfied for Section 17 to come into play.
Okay, now that we've got the theory and the conditions down, let's see how this all plays out in a real-world legal scenario. We're going to explore how Section 17 is applied in court. Let's take a very practical, exam-oriented example. Imagine A has a job to collect rent for B. Now B sues A saying A didn't collect the rent from a tenant C. A argues that C didn't owe any rent to begin with. Here's where it gets interesting. If C makes a statement saying, yes, I did owe rent to B, that statement is considered an admission. And it's admissible against A because it directly proves that rent was due, which means A was liable to collect it. See how that works? Now, to really ground this concept in judicial precedent, which is so important for your mains answers, let's look at a landmark case. The case you need to remember is Basan Singh versus Janki Singh, a really important decision from the Supreme Court back in 1967. So in this case, the Supreme Court held that statements made by persons whose legal status must be proved are admissible as admissions against parties deriving liability through them. Essentially, the court just confirmed the very principle we've been talking about. If Party A's liability depends on proving Party C's legal status, well, then Party C's own words about that status can be used against Party A. This ruling really is the backbone of how we interpret Section 17. Okay, let's switch gears and focus on the most critical part for you as an aspirant, the exam focus. Why is this section a high-yield topic, and what do you absolutely have to remember for your papers? Now, this is a really important point for your prelims, so pay close attention. Ye section, Section 17 of the Bharatiya Sakshya Adhiniyam 2023, has replaced what used to be Section 19 of the old Indian Evidence Act 1872. The core principle is exactly the same, but remembering this new section number is absolutely crucial. You don't want to lose easy marks on this. Let me be crystal clear about this. Judiciary prelims or mains, dono ke liye ye section bahut important hai. For prelims, you could get a direct question on the section number or its conditions. For mains, a problem-based question is highly probable. And for those of you preparing for APO exams, you can definitely expect a direct question that tests your understanding of this concept. It's a must-know. All right, let's do a very quick revision, just to lock in the key points. First, we are talking about Section 17 of the Bharatiya Sakshya Adhiniyam 2023. Second, the core concept is that an admission by a third person becomes relevant when their legal position is a key issue in the case. And third, remember its exam importance. This is a high-yield topic for both judiciary and APO exams. And that wraps up our detailed explainer on Section 17. I really hope the concepts are crystal clear for you now. For more judiciary-focused legal content just like this one, make sure you stay connected with Ganga Education. Thank you so much for joining us.
All right, let's talk about a situation you've probably seen a dozen times. You're in a dispute, and someone says, hey, don't take my word for it, go ask the expert. Sounds fair, right? But what happens when you do, and that expert's answer totally backfires on the person who sent you? Well, the law has a really slick answer for this. It's found in Section 18 of the new Bharatiya Sakshya Adhiniyam, and we call it the referee rule. Let's dive in and see how this simple but powerful rule keeps things fair in court.
So here's our game plan. We'll kick off with the classic story, get into the actual law, check out the 4 conditions that have to be met, understand the idea of fairness behind it all, see it in action with real cases, and finally, figure out just how powerful this kind of evidence really is.
To get our heads around this, we're going to start with a story that law students have heard for ages, the story of the unsound horse. It's the perfect example to show you exactly what this rule is all about.
Okay, picture this. Person A wants to sell a horse to person B, but B is cautious. There's one big question hanging in the air. Is this horse healthy? Is it sound? The whole deal depends on the answer. And here it is. This is the critical moment. Instead of just saying yes, A points to a third person, C, and says, go and ask C. C knows all about it. Now, A might think he's just being helpful, but what he's actually done is set a legal principle in motion, whether he knows it or not.
So, what happens now that C is involved? Well, this is where we stop telling a story and start looking at the law. Specifically, the clear-cut answer provided by Section 18 of the Bharatiya Sakshya Adhiniyam.
The legal idea here is something called adopted admissions. It's actually a pretty cool concept. When A told B to go ask C, the law says that A essentially adopted whatever C was about to say. It's like A put C on his team and agreed to be bound by C's answer. C's words are now legally A's words.
And here's the rule, right from the law itself. It's short, but it packs a punch. It says, if you expressly, and that's the key word here, point someone to another person for information, whatever that person says counts as your admission. You can't just take it back.
Now hold on. This rule doesn't just apply to any old casual chat. The law is very specific. For this to stick in court, there are 4 key conditions that have to be met. Think of it as a checklist.
First, there has to be a real dispute, like whether the horse is sound. Second, the referral has to be explicit, no vague hints. You have to clearly say, go ask that person. Third, the question has to be about the actual dispute. And fourth, the referee, person C, has to actually say something. If you take all 4 of those boxes, boom, the rule is in play.
Okay, so we know what the rule is, but why does it exist? What's the spirit behind this law? Well, it all boils down to one word, fairness. It's about preventing people from playing games in a legal fight.
At its heart, Section 18 is about keeping everyone honest. It stops someone from saying, go ask my expert, and then, if the expert gives a bad answer, turning around and saying, oh, never mind, that expert doesn't know what they're talking about. It forces you to be accountable. You pick the referee, so you have to live with their call.
There's a classic legal saying that nails this idea perfectly. Qui approbat non reprobat. All that means is, one who approves cannot later reject. You just can't endorse a source of information one minute and then try to throw it under the bus the next. The law demands you be consistent.
And here's another one that drives the point home. It basically says that the court won't even listen to you if you start contradicting yourself. If you told everyone that C's the authority on the horse, you can't then show up in court and argue that C's statement is worthless.
And finally, this is about protecting the other person. You can't change your tune if it's going to hurt someone who trusted you. In our story, B relied on A's referral to C. The law says A can't pull the rug out from under B now. It just wouldn't be fair. So, this all sounds good in theory, right? But how does it actually play out in real life? Let's check out how courts have used this rule and where you might see it pop up today. Because believe me, it's not just about horses anymore. The courts have been very consistent on this. In one case, Vasudev Krishna, a referral to someone just to clarify some details about a deal
was enough to be a binding admission. And in another big one, Basant Singh, the court said you don't even have to say the words. Your actions can show that you're accepting someone else as an authority.
And this happens all the time in the modern world. Think about it. A seller tells a buyer, "My surveyor can show you the exact property line." Well, guess what? They're now stuck with whatever that surveyor says. Or maybe a trader tells a client, "Talk to my accountant, he'll confirm the balance." That trader is now bound by the accountant's number. This rule is everywhere.
Okay, so we've established that the referee's statement is an admission. But here's the million-dollar question. What does that actually mean in court? How much power does it have? This is the final piece of the puzzle, and it's a big one.
Here's the key thing to remember. An admission like this is considered substantive evidence. That means it's a serious piece of the puzzle, and it's binding on the person who made the referral. But, and this is a huge but, it is not conclusive proof. It's not a silver bullet that automatically wins the case. It's more like a really strong punch, but it's not necessarily a knockout. The other side can still bring in other evidence to try and explain it or argue against it. It's powerful, for sure, but it's not unbeatable.
And that's really what it all comes down to. The rule is simple, it's fair, and it's absolutely crucial for keeping our legal system honest. If you point to someone and hold them up as the source of truth, you better be ready to stand by what they say. Because in the eyes of the law, their voice has just become your own.
You know how in movies they say, anything you say can and will be used against you? Well, what if you couldn't use those same words to help yourself? That's pretty much the starting point for Section 19 of the new Bharatiya Sakshya Adhiniyam. And today, we're going to break down exactly how this fascinating rule works, why it exists, and, most importantly, the exceptions that can completely change the game.
Before we jump into the legal text, let's start with this classic Latin phrase. It means, an admission is the queen of evidence. Now, that's not just some fancy old-school legal talk. It's the entire philosophy in a nutshell. It tells you just how seriously the law takes the things people say. So what's the big deal? Why is a simple statement considered the absolute queen of all proof?
So here's our roadmap. We'll start with why admissions are so powerful. Then we'll get into the weeds of Section 19 itself. After that, we'll look at the crucial exceptions, see some real-world examples, and finally, check out how the courts have handled all this. Let's get into it.
Okay, so let's tackle that first big question. Why all this talk about an admission being the queen of evidence? What makes a statement against your own interest so incredibly powerful in a courtroom?
Well, it really boils down to some pretty basic human psychology, right? Think about it. People just don't go around admitting to things that could get them into trouble, unless it's true. That self-incriminating nature gives the statement a ring of truth that's hard to deny, and that's what the law latches onto.
I absolutely love this quote because it's so vivid. Think of it like this. Your own words can become a sword in your opponent's hand, one they can use against you. But you're not usually allowed to use those same words as a shield to protect yourself. That's the main rule, the default setting. But, and this is a big but, every rule has its exceptions.
Okay, so let's get into the nitty-gritty. How does the law actually spell all this out? This brings us to the heart of the matter, Section 19. So the law defines an admission pretty broadly. We're talking about any statement, something you say, something you write, even something in an email or text. But here's the most important part. The whole point is that it can be used as proof against you or someone who legally stands in your shoes, like an heir or business partner. This right here, this is the whole thing in a nutshell. It's a one-way street. The stuff you say can be used against you, but you can't use it for you. And the reason for this is pretty straightforward, isn't it? The law wants to stop people from just making up convenient, self-serving stories after the fact to get out of a jam. But of course, it's not always that simple. And this is where things get really interesting. We've talked about the sword, so now let's talk about the shield. When can you actually turn the tables and use your own words to help yourself? Let's check out the 3 big exceptions the law provides. See, the law isn't totally inflexible. It knows that sometimes a statement you make for yourself is actually pretty reliable. So it builds in these 3 specific escape hatches. Each one has its own logic, so let's walk through them one by one.
All right, exception number 1. This is all about statements that have a kind of built-in truthfulness. Think of a pilot's logbook or a shopkeeper's daily accounts. These are records made as part of a routine, day-in, day-out process. The law basically says, hey, this person wasn't thinking about a future court case when they wrote this down, so it's probably legit, and that's why you can use it. Okay, exception number 2 is a bit more personal. It deals with your state of mind or how you're feeling physically. You can use your own words to prove what was going on in your head at a certain moment, but here's the huge catch. Your actions have to match your words. It's the old actions speak louder than words principle. If you said you were suspicious, your behavior at the time better show it. The two have to line up. And a third exception. You can think of this as the backdoor exception. If your statement is already important to the case for some other reason, maybe it explains a key action or is part of the story itself, then it can come into evidence. It gets in through another door, so to speak. It just so happens to also help your case. All right, enough with the theory. Let's make this real. The best way to understand these rules is to see them in action. And thankfully, the act itself gives us some fantastic examples. So check these out. The first one is a classic example of the main rule. You can't just say, oh, I've always said this deed is real to prove your case. Total no-go. But then look at the ship's captain. His logbook? That's a routine business record. So bingo, exception 1 applies. And for the last one with a suspicious currency, the person didn't just say they were suspicious. They took it to an expert. Their actions totally back up their words. That's a perfect example of exception 2 in action. Okay, so we have the rules from the law books. But how do they actually work in a real courtroom? For that, we've got to look at how the Supreme Court has weighed in over the years. These cases are huge because they tell us what the words on the page actually mean in practice. Let's start with a big one. Bharat Singh versus Bhagirathi. This case really gets to the core of just how powerful an admission can be. And what the court said here is absolutely critical. They ruled that an admission isn't just one little piece of the puzzle. Nope, it's substantive evidence. Now, that's a legal term, but what it means is incredibly powerful. An admission can be enough, all by itself, to prove a fact. You don't necessarily need anything else. A case could literally be won or lost based on that one statement. All right, next up is Narayan Gosavi. This case tackles a different but equally important question. If you make an admission, can you just say, oops, my bad, take it back later on? How binding is it really? The court came down hard on this one. The answer is yes, it's absolutely binding. Once you've made an admission, the shoe is on the other foot. It's now your job to convince the court you were mistaken or that there was some kind of error. And let me tell you, that is not an easy thing to do. If you can't explain it away convincingly, you're stuck with it. All right, let's zoom out and bring this all home. We've gone through the main rule, the clever exceptions, and what the highest court thinks. So what's the big picture takeaway here? Let's tie it all together. This chart does a great job of showing where Section 19 fits in. See, other sections handle the what and the who, what an admission is, who can make one. But Section 19 is the how. It's the action part. It's the rule book for how you actually use an admission in court. So if you take away just one thing today, let it be this. A person's admission is a weapon that can be used against them, but they usually can't use it as a shield to protect themselves. It all comes back to that core idea of reliability and fairness. The law trusts what you say when it hurts you, but it's skeptical when it helps you. It's that simple, and it's that important. And that leaves us with a final thought to chew on. We know an admission can trap you, that it can bind you, but when can it actually be the key that sets you free? The answer is tucked away in those 3 clever exceptions we looked at. It just goes to show you the law is always trying to strike a balance, not just between rigid rules, but between common sense and the constant search for justice.
Today, we're going to zero in on 2 really important sections that tackle a classic legal showdown. What happens when a spoken promise goes up against a written contract?
I mean, just picture this. You've got a signed agreement, but the other person swears you've verbally agreed to something totally different. So who does the court believe? That's the big question we're getting into. When does that solid black and white piece of paper officially trump a spoken promise that, could be forgotten or conveniently misremembered?
Well, the answer is actually spelled out for us in 2 key sections of this new law, Section 20 and Section 21. Together, they give us a pretty clear roadmap for how to handle this exact conflict. So let's break them down.
Okay, first up, we've got Section 20. And this one is all about the power of the written word. You see, the legal system has always struggled with how unreliable human memory can be. A written document, though, that's a fixed record. So this whole section is really about cementing its top dog status in a courtroom. There's this fantastic old Latin saying that just nails the idea behind Section 20. Spoken words fly away, written words remain. It's such a simple but powerful concept, right? What's written down sticks around. It has a kind of reliability that a conversation from 6 months ago just can't match. And that's really the foundation for everything we're about to talk about.
So how does the law enforce this? With something called the best evidence rule. And it's pretty much exactly what it sounds like. If you want to prove what's in a contract, what's the best possible evidence you could have? Well, the contract itself, of course. The court wants to see the original, not just hear somebody's version of it.
So the general rule of Section 20 is really straightforward. Anything you say orally about what's in a document is basically irrelevant in court. But, and this is a huge but, there are two major exceptions. One is when you're allowed to use secondary evidence, and the other is when the authenticity of the document itself is the whole point of the fight. And this is where it gets really interesting, because we need to understand when the court will actually listen to someone talk about a document. So let's take a closer look at these two game-changing exceptions.
So how does this first exception actually play out? Well, imagine the original contract was destroyed in a fire, or maybe the other side has it and is just refusing to hand it over. If you can prove to the judge that there's a legitimate reason you can't produce the original, then and only then does the door swing open for what we call secondary evidence. And at that point, your spoken testimony about what was in that lost document can actually be heard.
And this isn't just some abstract idea. The courts have come down hard on this. In a major case, Rup Kumar versus Mohan Thediani, the Supreme Court was absolutely crystal clear. Once you've put the terms of an agreement in writing, you can't just bring in some oral story to try and change it. Unless, of course, your situation fits squarely into one of those specific legal exceptions we're talking about.
Now, the second exception is just pure common sense. What if your entire argument is that the document itself is a complete fake? I mean, if someone shows up in court with a contract that has your forged signature on it, you obviously have to be allowed to give testimony to prove it's a fraud. In this case, your spoken evidence isn't about the contents of the document, it's about whether the document is even real in the first place.
Okay, let's switch gears. We've just seen how Section 20 is all about protecting the truth of written documents. Now, let's turn to Section 21, which deals with something completely different, but just as vital, encouraging people to settle their disagreements outside of court. I like to think of this section as creating a kind of settlement shield.
I mean, think about it. If you're in a legal fight, you might want to try and negotiate a compromise, but you'd probably be worried, right? What if you offer to settle for a smaller amount, and then the other side uses that offer against you in court as proof that your case is weak? That fear would totally shut down any chance of a deal. So how does the law get around this?
Well, it gets around it with a really smart legal tool called a without prejudice communication. Basically, this rule creates a safe zone for negotiations. It means that anything you say or any offer you make while you're genuinely trying to settle a case is protected. It can't be used as evidence against you if the talks break down and you do end up in court.
And the big idea here is summed up by another one of those great Latin maxims. It is in the public interest that litigation must end. Our courts are already slammed, and lawsuits are incredibly expensive and stressful for everyone involved. So the law recognizes that it's actually good for society as a whole to push people to resolve their own problems. Section 21 is the tool to make that happen.
So, for this protection to kick in, a few conditions have to be met. First, this is for civil cases. Next, an admission has to be made while you're actually negotiating. And critically, there should be an express statement, like putting the words "without prejudice" at the top of an email. Even if you forget that, a court can sometimes figure out from the situation that you both intended the conversation to be confidential. And if you tick those boxes, boom, that admission can't be used in court.
And yep, you guessed it, the Supreme Court has backed this up strongly as well. In the NTPC case, the court confirmed that once a document is marked without prejudice, it's protected. It's off limits as evidence of an admission. This really preserves the sanctity of the whole negotiation process.
So now we've looked at two very different rules. On one hand, you have a rule that limits spoken evidence to protect written documents. And on the other, you have a rule that protects spoken evidence to help people settle cases. Let's put them side by side to really appreciate the law's clever balancing act here.
And this chart just lays it out perfectly. Look at Section 20. Its purpose is all about safeguarding the truth in a document. The tool it uses is the best evidence rule, and the outcome is that it restricts what you can say. Then you have Section 21. Its purpose is totally different, to promote settlements. The tool is the without prejudice rule, and the outcome is that it protects what you say. It just shows how sophisticated the law is, using different rules to achieve two equally important goals: finding the truth and encouraging resolution.
And all of this brings us to one final big question for the future. These rules were created in a world of paper documents and in-person meetings, but we live in an age of WhatsApp chats that can be deleted, disappearing Instagram messages, and digital contracts. So the real question is, how are these fundamental principles, the power of the written word and the protection of settlement talks, going to adapt and evolve for our modern digital world? That's definitely something to think about. Thanks so much for watching.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.